Good morning. This is Rajeshkumar. Today we are going to discuss a theory question on specific performance. The video content has been made available for informational and educational purposes only. Kindly go through the disclaimer. Theory question. The specific performance should be more generally available as a remedy for a breach of contract. Discuss. Specific performance is an equitable remedy that compels a party to perform their obligation under a contract, as opposed to merely paying damages. Although it is a powerful tool, it is considered an exceptional remedy as courts typically prefer to award damages unless specific performance is deemed more appropriate. The restrictive approach to specific performance is deeply rooted in case law, particularly the landmark decision in Cooperative Insurance Society Limited versus Agrale Stores Holdings Limited in 1998. To address whether the specific performance should be more broadly available as a remedy for the breach of contract, we need to critically analyze the current legal framework, the condition under which the specific performance is granted, and the rationale behind its limited availability. Specific performance, unlike damages, is a discretionary remedy requiring the court intervention to enforce the exact terms of a contract. This remedy is governed by various conditions and limitations as highlighted by the case law, notably the Cooperative Insurance Society Limited versus Agrale Stores Holding Limited and other landmark decisions. This analysis explores whether the specific performance should be more widely available and examines the key bars to its application, such as the difficulty of supervision, contracts for personal services, and adequacy of damages. The contracts for personal services. One of the major bars to the specific performance is that it is generally not ordered in contracts involving professional regarding involving the personal services. What are the current restrictions on the specific performance? Specific performance is granted only under specific circumstances where damages would be inadequate. The doctrine prescribes limits to prevent unnecessary hardship, the economic inefficiency, and judicial entanglements in continuous oversight. The primary bars to specific performance involves contracts for personal services, difficulties in supervision, and the cases where performance might be impractical or impossible. In Cooperative Insurance Society case, the House of Lords clarified the rationale for not enforcing the specific performance in cases where the continuous supervision would be required. In agrarian stores, the closure of the supermarket in a breach of a lease terms presented a situation where the landlord sought the specific performance to keep the supermarket open. The claiming damages were inadequate. However, the court held that compelling the store to operate would be disproportionate, economically burdensome, and difficult to supervise, illustrate the general reluctance of the courts to enforce ongoing commercial obligations through specific performance. Evaluation of current bars. The contract for personal services. The court are cautious about enforcing contracts that require personal services due to the unique relationship, dynamics, and the need for trust, which is often disrupted by disputes. Specific performance in such cases could force the unwilling parties into the close collaboration, potentially leading to further conflicts. The president in page 1, Records Limiter versus Britain, underscores this point, where the court refused to compel a music group to work with a manager they no longer trusted, reinforcing that the court avoids imposing the specific performance in personal service contracts. In other words, one of the major bars to the specific performance is that it is generally not ordered in contracts involving personal services. Courts are reluctant to force the parties into a continuous personal relationship. As such, compulsion can lead to discord and difficulties in supervision. For example, in the page 1 case in 1968, the court refused to order a band to retain their manager since the personal nature of the relationship made specific performance inappropriate. Similarly, in Gills versus Morris case in 1972, Margaret J. explained that personal service contracts are difficult to supervise, especially when issues of performance quality may arise, leading to disputes over subjective evaluation of the services. We move on to the evolution of current was the second case, the difficulties of supervision. The continuous judicial oversight is another major concern. The courts are reluctant to enforce specific performance in cases that require monitoring compliance over time. Lord Hoffman, in Agrale case, emphasized that impracticality of courts managing ongoing commercial activities which may involve complex or indefinite obligations. The supervision can lead to a repeated litigation, placing the undue strain on judicial resources and increasing the potential for contempt proceedings against the breaching party. In other words, the another bar to the specific performance is the difficulty of supervision. In co-op versus Agril case, the House of Law refused to grant specific performance on a leases keep open covenant because enforcing it would have required a constant court intervention to ensure compliance. Lord Hoffman highlighted that impracticality of issuing orders that would lead to repeated appearances in court for contempt proceeding if breaches occurred. This reluctance is grounded in the idea that court should not be involved in ongoing supervision of performance, especially in commercial contracts. Next, we are going to the adequacy of damages. The specific performance is also limited to cases where damages are deemed inadequate. In contracts involving unique goods or land where the replacements are not readily available, damages might not fully compensate the aggrieved party, making the specific performance more appropriate as seen in cases like Beswick versus Beswick. In contrast, where substitute goods or services are available, the courts tend to favor damages to avoid compelling specific actions. In other words, the traditional position is that the specific performance is only available where damages are inadequate. For instance, Benke versus Beatty Shipping Limited in 1927, the court ordered a specific performance because the ship involved had unique qualities that made it irreplaceable. In contrast, in Metallurgist SA versus Bronze Engineering Co. Limited in 1975, the specific performance was denied as the machine in question could be replaced with another, making damages the sufficiency. A comparative analysis with the civil law jurisdictions. Civil law systems, such as those in France and Germany, generally offer a specific performance more readily, viewing it as a primary remedy. This approach aligns with the principle that the parties to a contract should honor their commitments as agreed. The common law emphasizes on damages as a primary remedy, reflecting a different underlying philosophy, focusing on a monetary compensation rather than enforcing obligations. While some scholars argue that a broader application of specific performance in common law could enhance the contractual commitment and fairness, other caution that this may lead to increased litigation and burdens on judicial resources. We'll move to the next point. Should the specific performance be expanded? Expanding the specific performance in common law might address certain inequities by ensuring the parties fulfill their contractual promises. For instance, in cases involving highly personalized goods or services that lack substitutes, specific performance ensures that the injured party receives precisely what was bargained for. Nonetheless, extending this remedy could potentially place undue burden on parties, especially when fulfilling the contract becomes uneconomical or requires long term judicial oversight. What about the efficiency of specific performance? Expanding the availability of specific performance may lead to more efficient outcomes in cases where damages do not truly compensate for a party's loss. For example, in long term contracts, the financial and operational disruptions caused by the breach may not be fully addressed through damages. The case of Sky Petroleum versus VIP Petroleum Limited in 1974, where the specific performance was ordered to secure a rare supply of oil, demonstrates how this remedy can prevent catastrophic consequences when the market substitutes are unavailable. Do you think that should the specific performance be more widely available? While the law places significant restrictions on the availability of specific performance, the question arises whether this should change. In many civil law jurisdictions, specific performance is the primary remedy for the breach of contract, and damages are considered secondary. Advocates for expanding the availability of specific performance in common law argue that doing so would better reflect the expectations and performance interest of the parties, promoting the fairness. How to restore the parties' expectations? The specific performance aligns with the performance interest of contracting parties. In some cases, damages simply compensate for financial loss without addressing the party's desire to see the contract fulfilled as agreed. By granting the specific performance more readily, the court could honor the contractual promises and restore the equilibrium that the parties intended. This is particularly true in cases involving unique goods or real estate, as seen in Johnson versus Agnew in 1980, where the specific performance is the preferred remedy of contracts involving the land. What are the challenges in expanding the specific performance? Well, the argument for broader use of specific performance is compelling. There are practical challenges. The courts are wary of becoming involved in disputes that may require continuous intervention or a micromanagement of performance. The issues identified in Co-op versus Argyll remain relevant as court cannot efficiently oversee the daily operations of the business or personal relationship. Additionally, expanding the specific performance may inadvertently encourage strategic behavior from the claimants who may use the threat of specific performance to extract concessions from the defendants. To conclude, while the specific performance serves as a valuable remedy in specific scenarios, its limitations aligns with the principles of practicality and judicial efficiency. The current restrictions help mitigate the risk of prolonged disputes and protect the parties from disproportionate obligations. Although the civil jurisdictions provide an alternative perspective by broadly enabling the specific performance, the common law, more cautious approach appears justified by the unique challenges of enforceability and supervision. Therefore, although there may be cases where expanding the specific performance could enhance a fairness, a broad reform may not necessarily lead to just or efficient outcomes across the board. In other words, while specific performance serves as a valuable remedy in specific scenarios, its limitations align with the principle of practicality and judicial efficiency. The current restrictions help mitigate the risk of prolonged disputes and protect the parties from disproportionate obligations. Although the civil jurisdictions provide an alternative perspective by broadly enabling the specific performance, the common law's more cautious approach appears justified by the unique challenges of enforceability and supervision. Therefore, although there may be cases where expanding the specific performance could enhance fairness, a broad reform may not necessarily lead to just or efficient outcomes across the board. Thank you.